Olga, for the organization of this great event. Well, in this presentation, I argue that there is a new legal indigenism emerging in Latin America, particularly in Peru, with the prior consultation law. I would like to analyze critically the prior consultation law from a decolonial perspective. So, the prior consultation law was a result of a very tragic event in Peruvian Amazon. A lot of indigenous organizations protested in Jan 2009 against a package of decrees approved by President Alan Garcia in order to implement the free trade agreement with the United States. These decrees were directed to facilitate the exploitation of natural resources in indigenous territories. So indigenous organizations argued that these decrees had to be consulted before their emissions. So they protested in order to recognize the recognition of the consultation law or consultation right. The result was terrible. A lot of people died among policemen and indigenous people. So I would like to answer the following questions. Before that, the new president in Peru, Ollanta, approved finally the prior consultation law in order to reduce social conflicts and to include indigenous people to the liberal, progressive Peruvian state. So I would like to answer the following question. Does consultation law overcome coloniality? Consultation law reduce social conflicts? And if consultation law contribute to the design of an intercultural state? So before answering those questions, it is important to understand the foundations of indigenous legality. An important element, or the most important element, according to my view, are the foundational rights of indigenous peoples. Indigenous people have foundational rights. I'm not talking about fundamental rights or human rights. Foundational rights, such as the right to self-determination and the right to territory. On the basis of those rights, indigenous people historically have built a whole legal framework of indigenous legality with collective and individual rights, with a holistic perspective, with a communal economy. Western legality, through different legal mechanisms, have attempted to eliminate this indigenous legality. So we have several legal doctrines, such as the doctrine of conquest, doctrine of discovery, or the doctrine of just war, directed to justify the appropriation of indigenous land by Western powers. We have also doctrines such as the terra nullius or dependent nations, directed to justify the idea of Western superiority, legal and economic superiority. So those legal doctrines were applied during colonization. Some of them were applied even after colonization. But after colonization, there was a change of paradigm from a process of violent exclusion, violent elimination of indigenous people and indigenous legality, to a process of violent inclusion, violent assimilation during the post-colonial era. Especially in countries like Peru, Bolivia, and Ecuador, with huge indigenous populations, the new nation states tried to include indigenous people, to assimilate indigenous people I think it's very important the colonial framework in order to understand these processes of exclusion and inclusion. According to the decolonial framework, we have to understand modernity as connected to coloniality. With modernity, we can observe two global processes, which, according to my view, are the foundation, the ontological and epistemological foundation of Western modernity. Two global processes are a global process of accumulation, by which Western powers can accumulate the richness from indigenous territories, and this process is related to a global process or to the economic development of Western powers and economic dependency of indigenous territory. Then we have a global process of naming or labeling the other, which is connected to the constitution of liberal rights, such as private property, and the denial of indigenous collective rights. So these two global processes are located at the very beginning of the conquest. And today we can see the continuities. We have that modernity has two main elements, which is liberalism, or today multiculturalism, and capitalism, or today economic development. This framework has a dark side. The dark side of liberalism is exception, and I will talk a bit about exception later. The dark side of capitalism is dispossession and exploitation, and the dark side of modernity is coloniality, or the denial of indigenous ontologies and epistemologies. So let's analyze the different stages of legal indigenism according to this view. During colonization, Spanish rules, Spanish legality implemented a whole legal system of grouping indigenous people in order to facilitate the collection of taxes, cheap labor, nomination, and so on and so forth. There were several means of resistance, and very important people. For example, de las casas, and my friend will talk about de las casas later, or mestizos such as Garcilaso de la Vega or Bonapoma. But an important means of resistance was the appropriation of Spanish legality by indigenous communities. So indigenous communities could survive legally in spite of the Spanish legality with this appropriation. They maintained their ancestral legal traditions and culture. With the independence, Bolívar eliminated these communities, and he created foster the idea of private property for indigenous people. And this was the beginning of the growing of hacendados or feudalists. As indigenous people were just small landlords, there were huge spaces to be occupied by the hacendados or feudalists. So we have the first wave of legal indigenism at the beginning of the last centuries. A lot of mestizo intellectuals started to think about the conditions of the indigenous people. And they proposed that indigenous people have to be recognized as communities and protect the land of indigenous people. So the first legal recognition was in 1920, the legal recognition of the indigenous community. However, the feudalist abuses, or the abuses of the hacendados, continued in the following decades because it was necessary agrarian reform. An important Peruvian intellectual, José Carlos Mariátegui, talked about this issue. For Mariátegui, the problem of the Indian was the problem of land. So the Marxist indigenism see the Indian as a rural proletarian. So in order to construct a process of revolution, socialist revolutions, the rural proletariat had to join the urban proletariat. So Paul was talking about solidarity. So solidarity for Mariátegui and for many today is that the indigenous people joined the agenda of the urban proletariat. So we have a second wave of legal indigenism in the 60s with Velasco president. Velasco was the fifth president in Peru that promoted, well, we have just one agrarian reform in Peru, and it was promoted by Velasco in the 60s. The idea was to transform the indigenous communities and something modern, so in the peasant communities. This process was implemented from a modernizing perspective, a left perspective, state socialist. So peasant communities were like European cooperative. It was in the Andes. In the Amazon, indigenous people have a very different reality than in the Andes. In the Amazon, most indigenous people have lived more autonomy than the Andes. The colonial rule has never been totally implemented in the Amazon, as in the Andes. However, Velasco implemented the legal figure of native community in the Amazon, taking as model the peasant community of the Andes. The result was that huge vital spaces of indigenous communities were reduced because the state just recognized small communities and not the whole territory of indigenous people. However, in the Andes and in the Amazon, indigenous people accepted that legality because it was a means for territorial defense. So they have no choice. And indeed, there was some special protection for indigenous people, so they accepted this legality. But, well, we have now a new process of legal indigenism because we have the consultation law. The consultation law according to international standards, the Convention 169 of the ILO, the International Labour Organization. It recognizes many rights for indigenous people. One of these rights is the right to be consulted before any administrative or legal norm is enacted. The state has to consult indigenous people if a law or administrative norm, it can be licenses for mining or oil exploitation, is approved, because these laws can affect collective indigenous rights. So I understand this context as a new legal indigenism, but still I identify several problems as in the past. As I mentioned before, we have to identify foundational rights. And we talk about the rights to self-determination and the right to territory as foundational rights. From my view, consultation, the right to be consulted, and the right, for example, which is recognized in the ILO Convention, the right to obtain economic benefit from extractive activities, these are no foundational rights. These are rights which can be understood in a context of global capitalism. the consultation law have two problems in that context. The first main problem is that the whole process of consultation is a process in which the state just informs indigenous people about the benefits of the norm or the mining licenses. And if indigenous people are not agreeing with the benefits of this norm or mining or oil licenses, just in that case, it emerged the stage of intercultural dialogue. So the state and communities will negotiate. And if indigenous people are not agreeing after that stage, there is the right of the state to take the final decision. The final decision is always to implement the project. In an intercultural state, it should be the other way around. The first stage should be to negotiate or to do an intercultural dialogue between the state and indigenous people to understand the priorities of the people. But the main problem is that consultation law makes to forget to invisibilize foundational rights. As I said at the beginning, the hope of many politicians, many even companies, was that consultation law would reduce social conflicts. But the real aim was to freezing indigenous politics into state new extractive policy. So that was the aim of consultation law. It is this logic of inclusion. Maybe not open violently as in the past, but it's other kinds of violence. Well, so my proposal is to pay special attention to foundational rights today of the indigenous people. I don't want to essentialize the indigenous people. Each people is very different. In the Andes and in the Amazon, there are different traditions. In Central America, in Australia, everywhere, indigenous people are different. But many of them are struggling for foundational rights. The rights to self-determination and the right to territory. Well, self-determination, that is the main problem, because many states argue that indigenous people cannot have self-determination because it will entail the cessation or the creation of new states. However, self-determination has different concepts, and indigenous people have struggled for different degrees of self-determination. For example, one Churchill is an American Indian. He talks about, or he has a very radical project of self-determination. That is true. But there are other kinds of self-determination. For example, James Tully talks about the constitution of a system of federal states. The decolonial project of Bolivia. And Bolivia is recognizing the plurinationality, this other kind of self-determination. And in most Latin American countries and constitutions, which are multicultural, there are some degrees of autonomy and self-determination. However, most indigenous people are not seeking to become independent nations, but to have a major power of decision on their vital spaces. What is the problem with this? Even in countries post-colonial and post-neoliberal, as Bolivia or Ecuador, in which there is a model of self-determination, a strong model, especially in Bolivia with plurinationality, there are some legal devices that allows the state by exception, to exploit natural resources. Even in natural parks, national parks, created for environmental purposes, or reserved for indigenous involuntary isolation, which are the most vulnerable, even in those areas, the state has the power to exploit natural resources on behalf of the national interest. So this power, which is a latent power, is justified because of the expression of state sovereignty or the necessity of economic development. So we can see here the continuities of the different states of legal indigenism. There is a similar rationale, just to conclude, there is a similar rationale in the different ways of legal indigenism. Recognition of indigenous rights according to Western parameters, norms of exception to impose the capitalist logic, and indigenous resistance and response to the appropriation of liberal realities. Indigenous people accept the idea of communal property as recognized by Velasco, the whole idea of human rights, universal human rights. They use the universal human rights, private property, or whatever legal Western device, because they use it for territorial defense. However, we should pay special attention to what I call foundational rights. The main challenges of consultation law is that consultation law cannot overcome coloniality, cannot reduce social conflict, and cannot contribute to an intercultural state. Because consultation law is embedded in the capitalist logic of expansion. So yes, my final words, the solution is to transcend discussions around consultation and pay attention to foundational rights such as self-determination and territoriality. That's it.